Good morning. Good morning, everybody. Namaskar. This is Engineer Suraj Singh speaking from Bharat, India. On this day, November 9, 2021, Friday, it's now 3:40 a.m. Early morning, 3:40. मैं सूरज सिंह सिविल इंजीनियर भारत इंडिया देश से बोल रहा हूँ। आज नवंबर 19, 2021 शुक्रवार और अभी 3:41 सुबह के, और मैं आपसे वार्ता के लिए उपस्थित, एबल टू टॉक टू यू अबाउट इंजीनियरिंग वर्ल्ड एंड क्वालिटी, गुणवत्ता और गुणवत्ता के लिए, सेफ्टी के लिए, related to quality, related to safety, communication and coordination, and title of this talk is Civil Field Engineering. And I am going to use both languages. English is prime language in stock, but Hindi is also a supportive language for those who may like to know what I am talking, though they may not understand everything, but just for purpose of communication, because there are a lot many people nowadays in our country as well as other countries who understand Hindi, and also common citizens of our country who may understand something. They should be informed accordingly. Maybe they do not go through details, but at least they should know what's happening. उन लोगों को भी जो हिंदी समझते हैं उनके बेनिफिट के लिए मैं कुछ हिंदी में भी बात करूँगा, लेकिन इंग्लिश प्राइम इसकी कम्युनिकेशन लैंग्वेज है. वी हैव टू अंडरस्टैंड दैट बिकॉज इट इज़ इंजीनियरिंग वर्ल्ड, and engineers read books in engineering in English, they work in English, though mathematics is not in English, formula are not in English, but to understand subject, English is communication language, and English is also coordination language. So it is, you can say, field engineering, life related to engineers, and engineers related to life, quality and contracts. Of course, certain disputes we are going to talk about. I have added disputes in this case because of issue of arbitration. I'll talk about that also. What happens in our country India, भारत, हमारे देश में किस तरह से disputes को handle किया जाता है, पूरी दुनिया में, विश्व में किस तरह से किया जाता है. Contracts means about FIDIC forms, and that is silver contract, which is EPC, as well as construction contract, that's Red Book, and other methods we are going to talk about organizations. And before that, this is certification. Here you have seen every day I show to you, and this is that certificate, which is a professional certificate based on experience and expertise. These certificates of chartered engineer, certificate of professional engineer, certificate of international professional engineer, these are not ordinary certificates. These are based on higher level of experience and qualifications. There are three categories of chartered engineers in our country, Bharat, India, and one is AMIE, other one is MIE, and third one is FIE. AMI is number one, that is least experience. MI is in between highest experience and least experience, and FI is top experience. Of course, qualification academics is degree plus masters plus PhD depending on what you are, and experience is adjusted accordingly. If you are a master's in engineering, then 1 year is allowed for counting of experience, and if you are doctor, then 2 years are allowed to give rebate on experience, and then you can say chartered engineer. India is considered competent engineers. आप कह सकते हैं सक्षम अभियंता काम करने के लिए, उसको बोलते हैं चार्टर्ड इंजीनियर. International engineer and international professional engineer are those who have separate cadre, and they are examined separately even if they are well educated. Experience is counted, their achievements are counted, that is called CPD, continuous professional development, which is very much important in addition to academic qualification, that is BE, ME or PhD, whatsoever one is. And that CPD is very important to understand. That puts a person into in-depth spectrum of engineering world. And because I belong to civil engineering community, civil engineering branch, so major task I do is civil engineering, but interdisciplinary engineering is very important from engineering point of view. Here is my email address, suraj_, don't forget this underscore, engineer@yahoo.co.uk, and you can, if you wish, write to me. This is certificate of International Professional Engineer. This is my third certificate. I got first certificate in 2012, that was International Professional Engineer. Then I got renewal of that in 2015, and after that in 2020, that is renewal year 30 September 2020, and it's valid up to 30 September 2025. So you can say I have been professional engineer since 1995, and I have been chartered engineer since 1981. I got AM charters, then I got 1986 M charter, and in 2016 I got F charter. I have worked for civil engineering construction and designs in overseas countries, in Iraq, in Libya, in Qatar, Doha, Qatar you can say, in UAE, and in Saudi briefly, and of course I have worked in Delhi for 6 years during start of my junior career, and it was in between 1975 to 1981 mid. This is my brief career. I have been involved in consultancy, in construction, in, you can say, normal designs, and writing of course, and this is Chartered Engineer India certificate, as I just explained to you, and this is Chartered Engineer India certificate of course, and I belong to Civil Engineering Division, and this is issued by Institution of Engineers India, which is having Royal Charter from King George V in 1935 got it, and it is same as it's given by Parliament, or it's given by Constitution, or it's given by President of this country. It's written by virtue of qualifications, professional training, and corporate membership of this institution. This person of this division is authorized to use style and title of Chartered Engineer, just like it's written here in professional certification that this person is certified as International Professional Engineer India in field of civil engineering, and is hereby authorized to use style and title of INTP India, and this certificate is valid up to this date. So this is common language, and this is fellow membership of same institution, which is according to Royal Charter, which is a statute or a constitutional power, and it is mentioned there in that this membership can be awarded. Then it's my file of quality. Very important file. I always try to show you this. In this file now I have introduced संचार तथा संतुलन अत्यंत आवश्यक, सही गुणवत्ता पाने के लिए. इन हिंदी आई एम टॉकिंग. संचार तथा संतुलन अत्यंत आवश्यक, सही गुणवत्ता पाने के लिए. कम्युनिकेशन एंड कोऑर्डिनेशन मोस्ट सिग्निफिकेंट disciplines subjects. What does it mean? Communication and coordination most significant disciplines subjects. So far I talked of quality, safety, health and environment, economics, contracts and products, quality in construction, and we talked about quality in production, manufacturing, quality in services, quality in education, quality in society. Now because it's important, जरूरी है समझना और समझाना कि गुणवत्ता आखिर कैसे आती है, क्या है, सेफ्टी से क्या लेना देना है, और शक्ति हमारी जो होती है हमारे शरीर में उसका कितना कैसे प्रयोग किया जाए काम में, कॉन्ट्रैक्ट्स क्या हैं, प्रोडक्ट्स क्या हैं, और गुणवत्ता से इनका क्या लेना देना है. इसके अलावा ये है कि प्रोडक्शन में हम जो भी उपज दें, प्रोडक्शन दें, जो भी प्रोडक्ट, मतलब ये कि क्या कहेंगे आप, जो भी आइटम हम प्रोड्यूस करें क्वालिटी की हो, हम उसको मैन्युफैक्चर करें या उसकी सेवाएं दें, या शिक्षा के बारे में बात करें, समाज के बारे में, व्यक्ति के बारे में, संचार के बारे में, साथ तालमेल के बारे में, जिसके भी विषय में, जिस कार्य के विषय में हम बात करें, उसमें क्वालिटी का होना आवश्यक है। क्वालिटी ज़िंदगी में होना बहुत आवश्यक है। इंजीनियरिंग में तो to explain to you, though it's not very big issue, everybody understands this, but understanding is not enough. If I understand something and if I don't apply that, my understanding got no meaning. If we know something, I say I have knowledge of this subject, but I don't understand this means I don't do it. If I knowledge of subject, I read that subject, I understand that, I analyze that subject, but I don't apply that subject. I don't apply that issue, that matter, that whatever title it is, whatever contents it has, then it's mean no meaning at all. That's why you say communication and coordination. Communication is very important because it is a medium through which we can inform someone or someone can inform us. This is reciprocal activity. If you want to communicate one person to another person and then another person to you or you to someone else, communication is only a medium, and communication means use of language, use of diagrams, use of drawings, use of writing statements, written statements, use of verbatim, verbatim means talking, and whatever way information can be provided to someone else. We name it communication, and it can be through whatever medium. It can be face to face, it can be paper to paper, it can be through emails, it can be through letters, it can be through hard copies, it can be through mobile, it can be through internet, it can be through whatever way. There is no restriction on this. In this age of computer and internet, it is very important because communications are missed, and coordination of communications also itself has been very difficult. I don't blame generations, I don't blame anybody because blaming is no meaning. My duty is to advise and suggest. Doing or not doing, accepting or condemning that what I say, what I suggest, that is your choice. I shall not be angry if you are not happy with what I say. I shall not be pleased also if you are going to accept what I say, because my point is, my focus is on improvement of quality. It's not my focus, my attempt is, and you too have same authority to do that, because you will be called a quality person if you do that, and if you don't do that, you cannot call yourself a quality person. Just like we say, item, matter, good, or whatever we produce, it should have quality. A person is also a kind of product. I am a product of this institution or this school or this university. Same way, you are a product from some school, some university or some institution. And that product, what sort of product you are, everybody knows about oneself. It's not that I have to tell someone what product you are. Yes, by my interaction with someone or with you, I may know something about you. And that interaction, if it is repeated, I can say I know more and more, and you know more and more about me, and I know more and more. We can say we know more and more about each other. Now, how much can you realize that? How much can you analyze that? What you get out of me, what I get out of you, your knowledge, I can realize, you can realize what level of understanding about engineering I have, what level of understanding about my profession I have, and say I know what you are. And what is your conduct? What's your ethics? Do you have that in-depth study, in-depth knowledge of that subject? You talk to me and I talk to you. And what's my level of understanding or development in that profession? Profession is not an ordinary discipline or branch. Profession means advanced study. Profession doesn't mean you just learn one thing and do. That's occupation. Occupation and profession are different words. Profession does not have any limit, it knows no bound. No bound. In English we say, I do not know any bound. I means I have no limit, I have no boundary. I can move to whatever level I want to move. I can go to whatever level. मेरी कोई सीमा नहीं है, मेरी कोई हद नहीं है. मैं कितना सीखूं मैं भी नहीं जानता, और आप कितना सीखें मैं आप भी नहीं जानते. सीखने की कोई सीमा नहीं होती, कोई लिमिट नहीं होती. हम कहीं तक भी सीख सकते हैं. जब तक हम जीते हैं जीवन में, सीखने का कोई अंत नहीं. ये आपके हाथ में है, आपके अपने कंट्रोल में है, आप कितना सीखें और कितना आगे जाएं। इसीलिए पढ़ाई एक लिमिट है, उसके बाद आपकी पढ़ाई आप खुद करेंगे, स्वयं करेंगे। You are a self-teacher, you shall be self-teacher, everybody has a self-teacher until one gets matured. If you are a student, you may not be self-teacher because lack of confidence. But when you start working in your life, you shall get knowledge on your own. Work teaches you, mistakes teach you, and achievements also teach you. You get experience that can be called good experience or bad experience. Both experiences are your guides, your future, you can say supports, and that is what experience is. For my for my thinking, for my analysis, based on my analysis, by my analysis, I can say experience, if real experience you have, may be good or may be bad, may be mistaken or may be correct, doesn't matter. Experience reminds you, experience tells you, XYZ, you did this mistake, don't do this mistake, try this way, you did at that side, that one, you did got calculation wrong in that design, you have to be careful. And that is what you see, your own records in your mind, your own files in your mind tell me, and that's fact of life. Engineering is fact of life, and same way mental record is fact of life. And this communication everybody does for itself. Your mind, your conscience, your past memories, your present memories, present energy shall certainly tell you, maybe a little late or maybe in advance, that you are going to do this. Care about this. आप ये करने जा रहे हैं, इसका ध्यान रखिएगा, नहीं तो ये गलत हो जाएगा। ये बातें होती हैं और इन बातों को समझना बहुत आवश्यक है। हर बात को लाइटली नहीं लिया जा सकता, ये भी सही बात है, और हर बात को पहाड़ भी नहीं बनाया जा सकता, ये भी सही बात है। एंड दैट इज़ व्हाट एक्सपीरियंस टीचेस अस। हम जब ड्राइंग में प्लान बनाते हैं, कहते हैं ये एक्सकेवेशन प्लान बनाइए, ये इसका प्लान बनाइए, सीधी लाइन ले लेते हैं। बिल्कुल ड्राइंग में ये लाइन है, ये हमारी एक्सकेवेशन की खुदाई करने की। क्या खुदाई सीधी लाइन में होती? नहीं होती। कहने का मतलब ये है, हम जब कोई भी चीज़ कार्य रूप से करते हैं, कार्यवाही के रूप में करते हैं, प्रैक्टिकल करते हैं, जिसको हम कहते हैं प्रैक्टिकल वर्क, उसमें और थियोरेटिकल में कुछ तो अंतर होता है, लेकिन अचीवमेंट होता है, हम कुछ प्राप्ति करते हैं। इसीलिए दिस टॉक ऑफ कम्युनिकेशन एंड कोऑर्डिनेशन इज़ वेरी सिग्निफिकेंट, मोस्ट सिग्निफिकेंट डिसिप्लिन। ये बहुत आवश्यक है, संचार और संतुलन बनाए रखना इतना आवश्यक है आपके लिए, आपके काम के लिए, आपके दोस्तों के लिए, आपके ऑर्गेनाइजेशन में सबके लिए और स्वयं के लिए। कम्युनिकेशन बनाना, करना, कोऑर्डिनेशन करना बहुत मुश्किल है और बहुत सरल भी है। ये डिसिप्लिन डिफाइंड नहीं है, ये सब्जेक्ट एक्सप्लेन नहीं है, लेकिन इस सब्जेक्ट के बिना हम कुछ भी नहीं कर सकते, ये भी समझना चाहिए। ये विषय कोई सिखाएगा नहीं आपको, कोई बताएगा नहीं आपको, लेकिन बचपन से ये स्टार्ट हो जाता है, हम इसको समझ नहीं पाते। किसी से बात करना कैसे करना, किसी को याद दिलाना कैसे दिलाना, किसी को बताना ऐसे करो ऐसा मत करो, जो भी इंटरेक्शन आप घर में करते हैं, अपने भाई बहनों से करते हैं, अपने माता पिता से करते हैं, अपने समाज से करते हैं, विश्व से करते हैं, वो सब कम्युनिकेशन ही तो है, संचार ही तो है। कुछ आप बोल कर करते हैं, कुछ लिख कर करते हैं, कुछ आर्गूमेंट से करते हैं, कुछ कैसे करते हैं, वट एवर मीन्स यू अडॉप्ट अबाउट कम्युनिकेशन, इट इज़ कम्युनिकेशन। मे बी देर इज़ नो रेफरेंस फॉर टाइम बीइंग, आप रेफरेंस यूज़ नहीं करते हैं कम्युनिकेशन में, जो इंटरनल बातें, एक्सटर्नल बातें आप करते हैं, कुछ भी जब तक आप जब तक किसी प्रोफेशन में नहीं आते हैं, ऑक्यूपेशन में नहीं आते हैं, जो रिकॉर्ड चाहिए आपको, अगर रिकॉर्ड चाहिएगा तो आपको रिकॉर्ड नंबर भी लेना होगा, रेफरेंस भी लेना होगा, वक्त से बताता है, समय बताता है। बार बार हर चीज़ को आप ढूंढ नहीं सकते, हर चीज़ आपके माइंड में गूगल या सर्च इंजन नहीं है। लेकिन जब आप किसी प्रोफेशन में आ जाएंगे, किसी ऐसी दुनिया में आ जाएंगे जहां आपके काम को यूज़ किया जाए, जब किसी के काम को यूज़ किया जाए, when somebody uses my work or your work or I use somebody else's works, then you can say reference is required. Even my own work shall become reference for you one time. Same way, your own work shall become reference for yourself. It's there very important. This topic of communication and coordination must be very clearly understood, without which we cannot reach anything, we cannot do anything. So quality and safety, ergonomics, contracts, products, all these are certain issues which give us quality system and system of quality. And if we don't follow these, if we don't use them, then we cannot achieve quality, and whatever we do, that has got no meaning, because that is at randomly done, and at random whatever is done, that cannot give us quality. And quality is a system which you have to devise yourself, nobody shall devise for us. Guidance may be there, everything may be there, but achievement or implication and you can say applications of those systems you have to do. You have to devise system and then you have to apply, and by applications only you can devise that system. So it is like you can say perpetual activity. There may be many activities in that activity, sub activities may be there, but all come back. It's like a 360-degree circle. It goes on moving and moving and moving and never stops. And quality does not stop, it never stops. It can be enriched, it is enriched, it get enriched. ये अपने आप को अमृत करती रहती है, अपने आप को आगे बढ़ाती रहती है, अपनी क्वालिटी खुद बढ़ाती रहती है, स्वयं बढ़ाती रहती है. इसलिए संचार तथा संतुलन अत्यंत आवश्यक सही गुणवत्ता पाने के लिए. और आप में संचार नहीं, संचार की कैपेसिटी नहीं, कोऑर्डिनेशन कैपेसिटी नहीं, तो आप कोई भी गुणवत्ता नहीं पा सकते. If you don't have any degree of capacity and degree of level of communication and conducting coordination, which are very essential to get quality work and to move quality system, to achieve that you have to work all on this. And if you're not able to do this, means you cannot work successfully, because you shall miss so many items, you may not be able to serialize them. And that's what I say, communication and coordination. World is full of communication, and it's only in your occupation or in your profession, when you come to do that, you understand what is communication. Because when you find something, where is that? If you want to search, you don't find that, you don't have any reference in which file I put it, then communication plays a role. So you have to system yourself, you have to do systemize yourself. If you cannot make your or fabricate your system, or you design your system, I am saying fabrication because it's assembly of some activity. System is not alone. It has communication and material both. Material and communication are two issues, and material here is, material means various materials in your communication, and those materials must be properly adjusted, properly linked to and worked upon, so that all these materials or substances which you are going to use in your work, those are, you can say, strength, or those are foundations, or those are references to coordination. So there's a little difference in this. People don't understand this. Communication is just a means of transmission, while coordination is a means of technical work. How work should be done, which activity should come first, which is second one, how they should relate to each other, how can we pile them up? They can be serially piled, or they can be parallel piled, or grouped. Various ways are there. How can they be merged or linked, or whatever it is. At one time they should come together whenever they are called in. There may be 15 activities, all should work together if it's required, and how can we force them to work together? That's our job, and that job is called coordination. There's nobody senior, nobody junior in that. Nothing is inferior, nothing is superior in that. All should act one time. It's like my mind and my body. How my body feels, how my body performs, my mind understands. And what my body has to do, my mind can tell. And that's what is coordination. Body working, body functioning is best example of coordination. Everybody's body coordinates. Everybody's structure coordinates. If my body is unable to coordinate, then I cannot think, I cannot work. If my mind doesn't cooperate with body, or body doesn't cooperate with mind, then you can say this person has no sense. You can say this person has no awareness, this person has no sensitivity, and this person cannot communicate within its own system. And that's why I say communication is missed and coordination is elapsed. That should not happen. That is very important point, and that's the reason that I try to start with communication and coordination, which are most efficient and effective means to run something. There's no subject, but it is super subject, you can say. It works in every field, in every discipline, in every sphere of life, in every professional life, occupation of life, work or life. No, like means there's no place where you will not find communication. Spoken communication works everywhere. Yes, written communication will work somewhere else, but not everywhere. Those people who cannot write, they communicate by speech. They communicate by signals. Even those who cannot speak, they communicate by signals. So communication still exists. Coordination means how can you respond to one communication matter, how can you respond to other one, and that is reciprocal communication. You can say responsive communication. But if you have substance to respond, only then you can communicate or reciprocate of communication, reciprocation of communication, and coordination, that is called. So coordination means it may be on x-axis or it may be on y-axis. It should work together. Quality achievement is duty of everybody, and quality means there is no end. It should be realized. It's a mixture everywhere. Individual quality is too significant. Individual quality which starts from childhood, which starts from infancy, but we do not realize. We can say, okay, this baby is very nice, this baby is capable. That capability, you can say, is kind of equivalent word to quality. We do not say quality, but actually it is quality. So quality baby, this is quality person, this is quality boy, this is quality student, this is quality player, this is quality studious person. Likewise, because it is quality young man, this is quality young boy, young girl, and this is quality youth, this is quality public, this is quality society. Likewise, we can say, but we don't define quality. We leave it to what is acceptable to some society. We don't define that because we do not entitle that. We say, okay, they are quality people, this is quality group. We just leave it otherwise because we don't find any bad in them, any bad point in them. We say, okay, they are good people, they conduct properly. You may say conduct here is defined as quality. Conduct or ethic or standards, there is no standard at all according to international or national standards, but we can say, okay, they are good people, they are good citizens, they conduct properly, they don't harm someone else, they live peacefully, the society, this area is peaceful, there is no law and order problem. In that case, in fact, you can say this is a collection of quality requirements. You should be peaceful, society should be good, you should have good ethics, you should conduct properly. आपको कैसे बिहेव करना चाहिए लोगों से, शांति बनाए रखना चाहिए, आराम से रहना चाहिए, दंगे नहीं करने चाहिए, किसी की बेइज्जती नहीं करनी चाहिए, अपनी इज्जत करानी चाहिए और समाज में अच्छी तरह आगे बढ़ना चाहिए. इस तरह की जो अनडिफाइंड है सिस्टम, इसको भी हम क्वालिटी कहेंगे. क्वालिटी सोसाइटी, क्वालिटी अगर आपको कहीं पढ़ाई करनी है, कोई इंस्टीट्यूशन अच्छी आपको एजुकेशन देता है, वो भी क्वालिटी इंस्टीट्यूशन है. अब उसको आप नेशनल प्रेस्टीज कह लीजिए, कुछ भी कह लीजिए, फ़र्क नहीं पड़ने वाला. क्वालिटी कहीं ना कहीं सब जगह लगती है. आप एक गाड़ी खरीदते हैं, अच्छी चलती है, बहुत अच्छा रेटिंग देती है, तो आप कहते हैं अच्छी गाड़ी क्वालिटी वाली है. यही चीज़ें होती हैं. कोई भी प्रोफेशन, कोई भी काम, कोई भी बिजनेस, अगर आप अच्छा सेवा करते हैं, समाज को देते हैं, तो क्वालिटी का कहेंगे. लेकिन आजकल ऐसा देखने में नहीं मिलता है. या तो आपको पुश करना पड़ेगा, लड़ाई करनी पड़ेगी लोगों से जो होती है, या आप सोते रहिए, कोई आपको कुछ नहीं कहेगा. हमारा समाज एक सोने वाला, एक स्लीपिंग सोसाइटी बन चुका है. बड़े दुख की बात है. हम क्वालिटी ना होके, हम क्वालिटी ना समझ के गलत रास्ते पे जा रहे हैं. एक मिनट दीजिए प्लीज़. क्वालिटी इज इम्पोर्टेंट. गुणवत्ता हर जगह कैसी होनी चाहिए हमने समझा जाना, और इसकी एक्सप्लेनेशन कितनी भी लंबी कर दी जाए इसमें कोई अंत नहीं हो सकता. वी हैव टू अंडरस्टैंड दिस पॉइंट दैट quality cannot be redefined and redefined. It has to be redefined in fact. Life is engineering based. We have to justify, we have to show, we have to prove. Engineering is domain, we have to say गुणवत्ता हर काम में आवश्यक, सुरक्षा बिना काम बेकार. So this we have to understand. I don't know repeat, I just tried to add this here yesterday and I said okay, let us talk about communication coordination, and also we put it at and also same that quality can never be and must not be compromised by engineers and public. हम क्वालिटी को कभी भी कॉम्प्रोमाइज़ नहीं करना चाहिए, गुणवत्ता से हम खेल नहीं सकते, और इंजीनियर्स तो बिल्कुल नहीं, पब्लिक भी नहीं. क्वालिटी चाहे वो प्रोडक्ट की हो या किसी सेवा की हो, हम उससे खेल नहीं सकते. शायद ये 18:10 गलत लिखा गया, 18:11 है, सॉरी फॉर दैट, आई विल करेक्ट इट. संचार तो संतुलन अत्यंत आवश्यक है, जो हम पहले कह चुके हैं. एंड कम्युनिकेशन कोऑर्डिनेशन मोस्ट सिग्निफिकेंट डिसिप्लिन सब्जेक्ट्स, और ये हमको अच्छी तरह से समझ लेना चाहिए सब कुछ. मैं ये नहीं कह रहा कि क्वालिटी हमारे ही यहाँ ख़राब है, बहुत सी जगह ऐसी हैं जहाँ क्वालिटी ख़राब है दुनिया में, और वो कोई भी जगह हो, हम सब के लिए बात कर रहे हैं. इट कैन नॉट बी एक्सेप्टेड, एंड आई क्लोज दिस फाइल, also close this file so that there is space, enough space. And I was talking about FIDIC contracts, that is silver book, EPC, और हमने I talked about this. I have at other point, and that point was, it was I'm sorry, this is not 122, it should be I think 110 somewhere, let us say. And I so we talked about 19 and 20. I was talking somewhere about arbitration. I remember we talked about class 21. Yes, we talked about distribution of the arbitration, and of course failure to appoint DAPs we talked about. Then we talked about avoidance of dispense, evidence of disputes, obtaining DAP's decision. Then we can say after the amicable settlement we talked of about this little, and we said that where NOD has been given under NOD, that is no notice of dissatisfaction. Notice of dissatisfaction has been given under obtaining DAP's decision. Both parties shall attempt to settle dispute amicably before the commencement of arbitration. और arbitration का मतलब है मध्यस्थता, जैसे हमने कल पढ़ा. However, unless both parties agree, otherwise arbitration may be commenced with on or after 20th day after date on which NOD was given, even if no attempts at amicable settlement has been made. अब आइए आर्बिट्रेशन, जो हम बात कर रहे हैं. मैंने आर्बिट्रेशन एक्ट की बात की थी. आई टॉक्ड अबाउट आर्बिट्रेशन एक्ट इन आवर कंट्री. इसमें देखिए लिखा है अनलेस सेटल्ड एमिकेबली, अगर आप आपस में बातचीत करके अपने झगड़े सुलझा सकते हैं. अनलेस सेटल्ड एमिकेबली एंड सब्जेक्ट टू डिससेटिस्फैक्शन विद एम्प्लॉयर्स रिप्रेजेंटेटिव डिटर्मिनेशन. जो आपके इंजीनियर ने या एम्प्लॉयर ने या डैब उसको नहीं मानते तो अलग बात है. फेलियर टू कंप्लाई विद डिसीजन, जो भी इसके रीज़न हो, इसमें कह सकते हैं कि डैप डिसीजन फाइनल नहीं हुआ. इट सेज then settled by international arbitration unless otherwise agreed by both parties. I read again. Unless settled amicably and subject to dissatisfaction of the employer's representative determination, dissatisfaction of DAP's decision, failure to comply with DAP's decision, and DABs in no DAB in place and dispose disputes in respect of which DAB decision has been final and binding shall be finally settled by international arbitration unless otherwise agreed by both parties. हमने सब कुछ कर लिया भाई, इंजीनियर को बोल दिया, डैब को बोल दिया, डैब नहीं है तो कोई बात नहीं है, हम सीधा जा सकते हैं आर्बिट्रेशन में। अब हमारी स्टेज ऐसी आ गई है कि हम कोई बात नहीं कर सकते, हमारे आपस में बातें नहीं बन पा रही हैं, तो भाई आर्बिट्रेशन ही रास्ता रहता है। और वो आर्बिट्रेशन क्या है वो हम बताएंगे। एंड सेज डिस्प्यूट शैल बी फाइनली सेटल्ड अंडर रूल्स ऑफ आर्बिट्रेशन of International Chamber of Commerce. Dispute shall be settled by one or three arbitrators appointed in accordance with these rules. Arbitration shall be conducted in ruling language defined in contract law and language. Arbitrators shall have full powers to open up, review and revise whatever certificate, determination other than a final and binding determination. जो भी डिटर्मिनेशन इंजीनियर ने की या डैब ने की उनको रीओपन किया जा सकता है, क्योंकि वो फाइनल एंड बाइंडिंग नहीं है आर्बिट्रेटर से पहले, आर्बिट्रेशन से पहले। आर्बिट्रेटर शैल हैव फुल पावर टू ओपन अप, रिव्यू एंड रिवाइज एनी सर्टिफिकेट, डिटर्मिनेशन अदर देन फाइनल एंड बाइंडिंग डिटर्मिनेशन, इंस्ट्रक्शन, ओपिनियन और वैल्यूएशन ऑफ एम्प्लॉयर and or of employer's representative and whatever decision of DAB other than a final and binding decision relevant to dispute, nothing shall disqualify natural person who have acted on behalf of employer under contract from being called witnesses and given evidence before arbitrators or whatever matter whatsoever relevant to dispute. In whatever award dealing with cost of arbitration, arbitrators may take account of extent to which a party failed to cooperate with other party in constituting DAB, constitution of DAB and or failure to appoint DAB members. Neither party shall be limited in proceedings before arbitrators to evidence of arguments previously but put forth before DAB to obtain its decision or to reasons for dissatisfaction in parties notice of dissatisfaction under subclause obtaining DAB's decision. Decisions of DAB shall be admissible in evidence in arbitration. Arbitration may be commenced before or after completion of works. Obligations of parties and DAB shall not be altered by reason of whatever arbitration being conducted during progress of works. If award requires a payment of an amount by one party to other party, this amount shall be immediately due and payable without whatever statement or notices. Failure. So now this is what after that is failure to comply with season, no DAB are in place, and we'll see. So let us say this general condition of dispute avoidance. Explanation here, we must understand what is this actually. We should go to, in fact, I should open something which is very important in this connection, and I try to open the file arbitration and conciliation. Let us see, first of all, in our country Bharat India, what is that? I'll just now try to show you Arbitration and Conciliation Act 96. This is where it is, and let us see what it is. First we'll see later on amendments. This is, this what I'm going to show you. These are long pages, but no problem. इसमें कितने सुधार हुए हैं, कितने अमेंडमेंट हुए हैं in 1915, 2015, 2018, 2020 or 21. There have been some modifications, some amendments. We'll go through that. First we understand Arbitration and Conciliation Act 96. मैं सिर्फ डेफिनेशन से स्टार्ट करता हूँ, इंट्रोडक्शन को छोड़िए। वो कहते हैं दिस इज डेफिनेशन इन दिस पार्ट अनलेस कॉन्टेक्स्ट अदरवाइज रिक्वायर्स व्हाट इज आर्बिट्रेशन। इट मीन्स arbitration whether or not administered by permanent arbitral institutions। वो arbitration चाहे वो institution के थ्रू हो या सीधी हो, arbitration means that this is original definition। what is arbitration agreement? Means agreement referred to in section 7, and what is section 7? We'll go to see that section 7. Let us first see section 5, section 6, and this is arbitration agreement in this act। The arbitration agreement says, let's blow it up please, yeah. Section 7 says, arbitration agreement definition is here in Act 96, 1996, Arbitration and Conciliation Act 1996, 1996 का मध्यस्थता का नियम क्या है? आर्बिट्रेशन एक्ट मध्यस्थता का एग्रीमेंट क्या है? स्टैट्यूटरी एग्रीमेंट है ये कोई मेरा या आपका दिया नहीं है, ये एक्ट में प्रोविजन है, तो ये मना नहीं किया जा सकता। यू कैन नॉट गो अगेंस्ट दिस आर्बिट्रेशन एग्रीमेंट। इन दिस पार्ट आर्बिट्रेशन एग्रीमेंट मीन्स एन एग्रीमेंट बाय पार्टीज टू सबमिट टू आर्बिट्रेशन all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship whether contractual or not। इसका मतलब क्या है? पहले में जो दिया है, कोई भी एग्रीमेंट जो हम कह रहे हैं आर्बिट्रेशन एग्रीमेंट दोनों पार्टीज के बीच में है। कौन सी पार्टीज? विच पार्टीज दे आर? वन इज एम्प्लॉयर एंड वन इज कॉन्ट्रैक्टर। Simple. Party 1 is employer and party 2 is contractor. It is generally defined like this. We say here and after called employer and hereafter called contractor is that। अब के बाद हम इसको इस X पार्टी को एम्प्लॉयर कहेंगे और इस Y पार्टी को हम कॉन्ट्रैक्टर कहेंगे, ऐसा एग्रीमेंट। और उसमें कहा जाए कि ये दोनों मानते हैं, एम्प्लॉयर और कॉन्ट्रैक्टर ये दोनों एग्री करते हैं, ऐसा क्लॉज उसमें हो या अलग से हो कि हमारा कोई झगड़ा होगा जो भी किसी भी तरीके का इस काम पे, इस एग्रीमेंट पे, इस प्रोजेक्ट पे, ये झगड़े किस तरह के झगड़े होंगे? पैसे के लेन देन के या किसी और चीज़ के, क्रिमिनल केस के नहीं, सिविल केसेस के, जो जिसमें सज़ा नहीं होती वो केस, जिसमें फाइनेंस का इफेक्ट पड़ता है वो केस हम आर्बिट्रेशन में देंगे। जो भी आर्बिट्रेशन हम अपॉइंट करेंगे, जो भी झगड़े होंगे हम उनको देंगे, और उनको देंगे जहाँ रिलेशनशिप हमारी आपस में लीगल, मैं कॉन्ट्रैक्टर हूँ और ये एम्प्लॉयर हैं, हम दोनों का ये नियमित रिश्ता है चार्टर के हिसाब से, कॉन्ट्रैक्ट के हिसाब से, इंडर किसी भी कंट्री के लॉ के हिसाब से, कॉन्ट्रैक्ट लॉ के हिसाब से एक लीगल रिलेशनशिप है। ऐसी लीगल रिलेशनशिप मना नहीं की जा सकती। एन आर्बिट्रेशन एग्रीमेंट may be in form of an arbitration clause in a contract or in form of a separate agreement। कॉन्ट्रैक्ट के अंदर क्लॉज से आपने एग्रीमेंट डाला, आर्बिट्रेशन क्लॉज का, कैसे हम आर्बिट्रेशन करेंगे, कैसे हम झगड़े सुलझाएंगे। एन आर्बिट्रेशन एग्रीमेंट may be in form of an arbitration clause in a contract or in form of a separate agreement। अलग से भी आप इसको कभी भी कर सकते हैं, कॉन्ट्रैक्ट के समय या बाद में। एन आर्बिट्रेशन एग्रीमेंट शैल बी इन राइटिंग। आर्बिट्रेशन का जो एग्रीमेंट होगा वो राइटिंग में होगा। आर्बिट्रेशन एग्रीमेंट इज इन राइटिंग इफ इट इज कंटेन्ड इन। आर्बिट्रेशन एग्रीमेंट राइटिंग में है अगर ये लिखा है, ए डॉक्यूमेंट साइन बाय पार्टीज, वो दस्तावेज दोनों पार्टीज ने साइन किया है। एन एक्सचेंज ऑफ लेटर्स, या हमने लेटर्स को एक्सचेंज किया, टेलेक्स को दिया, टेलीग्राम किया, या कोई भी संचार का माध्यम, अदर मीन्स ऑफ टेलीकम्युनिकेशन विच प्रोवाइड ए रिकॉर्ड ऑफ एग्रीमेंट, वो माध्यम जो हमको देता है सारे रिकॉर्ड एग्रीमेंट के। एक्सचेंज ऑफ स्टेटमेंट ऑफ क्लेम्स एंड डिफेंस इन विच एक्सिस्टेंस ऑफ एग्रीमेंट इज एलिज्ड बाय वन पार्टी एंड नॉट डिनाइड बाय अदर पार्टी। ऐसे स्टेटमेंट दस्तावेज में उन स्टेटमेंट को एक्सचेंज किया जाए, दावे को वो दावा जो हम कर रहे हैं, स्टेटमेंट ऑफ क्लेम्स हम उसको कहते हैं, जो भी हमारा दावा है, दावे को हिंदी में क्या कहेंगे, खैर जो भी हमारी डिमांड है, लीगल डिमांड है, उसको एक्सचेंज कर रहे हैं या उसको डिफेंस कर रहे हैं। एग्रीमेंट के तहत एक पार्टी कहती है कि मेरा ये दावा है और दूसरी उसको मना नहीं करती है या कुछ और कहती है। रेफरेंस इन ए कॉन्ट्रैक्ट टू डॉक्यूमेंट containing an arbitration clause constitutes an arbitration agreement if contract is in writing and references such as to make that arbitration clause part of contract। कहीं भी दस्तावेज में अगर आर्बिट्रेशन के बारे में लिखा है वही आर्बिट्रेशन एग्रीमेंट है, और कॉन्ट्रैक्ट राइटिंग में है और उसमें रेफरेंस है कि आर्बिट्रेशन क्लॉज है, वो भी आर्बिट्रेशन कॉन्ट्रैक्ट है। तो ये क्या कहता है, देखिए, इन दिस पार्ट आर्बिट्रेशन एग्रीमेंट मीन्स एन एग्रीमेंट बाय पार्टीज टू सबमिट टू आर्बिट्रेशन all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. An arbitration agreement may be in form of an arbitration clause in a contract or in form of separate agreement. An arbitration agreement shall be in writing. An arbitration agreement is in writing if it is contained in a document signed by parties. An exchange of letters, telex, telegram, or other means of telecommunication which provide record of agreement, or an exchange of statements of claims and defense in which existence of agreement is alleged by one party and not denied by other party. Reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if contract is in writing and reference is such as to make that arbitration clause part of contract. So we are studying act. Now what are comments? Writer क्या कहता है comments में? Competence of arbitrator. Arbitrator is competent to decide objection on its own jurisdiction. Arbitrator is competent, is given competence of arbitrator. क्या कैपेसिटी होनी चाहिए आर्बिट्रेटर की, मध्यस्थ की? Arbitrator is competent to decide objection on its own jurisdiction, whether appointed for terms of agreement within provisions of section or appointed under provisions of section. This was given in some decisional case by court. What constitutes an arbitration agreement? क्या है arbitration agreement? What constitutes an arbitration agreement? Well settled principles in respect thereof. In regard to what constitutes an arbitration agreement, well settled principles are, क्या है वो सिद्धांत जो एग्रीमेंट बनाते हैं? देखिए इसमें लिखा है, intention of parties to enter into arbitration agreement shall have to be gathered from terms of agreement. एग्रीमेंट में क्या लिखा है, टर्म्स क्या है? Intention of parties to enter into an arbitration agreement shall have to be gathered from terms of agreement. If terms of agreement clearly indicate an intention on part of parties to agreement to refer their disputes to a private tribunal for adjudication and willingness to be bound by decision of such tribunal on such disputes, it is arbitration agreement. While there is no specific form of an arbitration agreement, words used should disclose a determination and obligation to go to arbitration and not merely contemplate possibility of going for arbitration. Where there is merely a possibility of parties agreeing to arbitration in future as contrasted from obligation to refer disputes to arbitration, there is no valid and binding agreement, arbitration agreement. अभी क्या कहना चाहता है, हमारा एग्रीमेंट जो हमने किया है, कॉन्ट्रैक्ट जो किया है, उसके अंदर इंडिकेशन होनी चाहिए साफ साफ कि हमारे जो भी झगड़े होंगे वो हम आर्बिट्रेशन के थ्रू सॉल्व करेंगे, और अगर ऐसा नहीं है तो बाद में भी किया जा सकता है। हमारी इच्छा है कि हम झगड़े ऐसा अपना एक ट्रिब्यूनल बना के सॉल्व कराएं, और वो ट्रिब्यूनल में दोनों जिम्मेदार हों, दोनों पार्टी, जिसे हम आर्बिट्रेशन एग्रीमेंट कहते हैं। कॉन्ट्रैक्ट की लैंग्वेज ऐसी होनी चाहिए, ये नहीं होनी चाहिए कि अगर ऐसा होगा, हो सकता है हम ऐसा करें, हो सकने वाली बात उसमें नहीं चलेगी। और स्पेसिफिकली होना चाहिए कि अगर हमारे बीच में कोई भी डिस्प्यूट आते हैं वर्क के बारे में, पैसे के बारे में, सिविल कोई भी ऐसा डिस्प्यूट जो आर्बिट्रेशन एग्रीमेंट के स्कोप में आता है तो हम उसको आर्बिट्रेशन को देंगे। इसमें हंसी मजाक वाली बात नहीं है। हम उसमें यह होना चाहिए कि हम इसको किसी भी आर्बिट्रेशन के थ्रू सॉल्व करेंगे। अगेन आई रीड, intention of parties to enter into an arbitration agreement shall have to be gathered from terms of agreement. If terms of agreement clearly indicate an intention of parties to agreement to refer their disputes to private tribunal for adjudication and a willingness to be bound by decision of such tribunal in such disputes is arbitration agreement. While there is no specific form of arbitration agreement, words used should disclose the determination of the obligation to go to arbitration, not merely contemplate possibility of going for arbitration, where there is merely a possibility of parties agreeing to arbitration in future as contrasted from obligation to refer disputes to arbitration. There is no valid and binding arbitration agreement. Even if words arbitration and arbitration, arbitral tribunal or arbitrator are not used with reference to process of settlement or with reference to private tribunal, which has to adjudicate upon disputes in a clause relating to settlement of disputes, it doesn't detract from clause being an arbitration agreement if it has attributes or elements of an arbitration agreement. I read again. Even if words arbitration and arbitral tribunal or arbitrator are not used with reference to process of settlement or with reference to private tribunal, which has to adjudicate upon disputes in a clause relating to settlement of disputes, it doesn't detract from clause being an arbitration agreement if it has attributes of elements of arbitration agreement. Their agreement should be in writing. That's number one. Parties should have agreed to refer whatever disputes or any disputes, present or future, between them to decision of private tribunal, and other one is private tribunal should be empowered to adjudicate upon dispute in an impartial manner, giving due opportunity to parties to put forth their case before it. Parties should have agreed that decision of private tribunal in respect of disputes shall be binding on them. Where clause provides that in event of dispute arising between parties, dispute shall be referred to arbitration, it is an arbitration agreement. Where there is a specific and direct expression of intent to have disputes settled by arbitration, it's not necessary necessary to set out attributes of an arbitration agreement to make it an arbitration agreement, but where clause relating to settlement of disputes contains word which specifically excludes any of attributes of an arbitration agreement or contains anything that detracts from an arbitration agreement, it shall not be an arbitration agreement. For example, where an agreement requires or permit an authority to decide a claim or dispute without hearing, or requires authority to act in interest of only one of parties, or provides that decision of authority shall not be final or binding on parties, or that if either party is not satisfied with decision of authority may file a civil suit seeking relief, it cannot be termed as an arbitration agreement. But mere use of word arbitration or arbitrator in a clause shall not make it an arbitration agreement if it requires to contemplate further or fresh consent of parties for reference to arbitration. For example, use of words such as parties can, if they so desire, refer their disputes to arbitration, or in event of whatever dispute, parties may also agree to refer same to arbitration, or if whatever disputes arise between parties, they should consider settlement by arbitration in a clause relating to settlement of disputes, indicate that clause is not intended to be an arbitration agreement. Similarly, a clause which states that if parties so decide, disputes shall be referred to arbitration, or whatever disputes between parties, if they so agree, shall be referred to arbitration, is not an arbitration agreement. Such clauses merely indicate a desire or hope to have disputes settled by arbitration, or a tentative arrangement to explore arbitration as a mode of settlement. If and when a dispute arises, such clauses require parties to arrive at a further agreement to go to arbitration. As and when disputes arise, whatever agreement or clause is an agreement requiring or contemplating a further consent or consensus before a reference to arbitration is not an arbitration agreement. Now I'll go to what is arbitration, Council Act 96, and power to refer parties to arbitration where there is an arbitration agreement. Now I'm just reading this original act. We'll consider amendments later on just for information what this act is, because if we do not understand what original act is, we cannot clearly understand or know about amendments, how they operate. So power to refer parties to arbitration before arbitration where there is an arbitration agreement. अब अभी तो हमने देखा था कि हम arbitration agreement कैसे डिफाइन किया, जहाँ क्लियर कट है कि डिस्प्यूट को आर्बिट्रेशन में देना है, वो किसी भी रेटिंग वर्ड्स में हो, किसी भी टर्म्स में हो, ज़रूरी नहीं इसमें आर्बिट्रेशन डिफाइन हो, लेकिन वहाँ पर आर्बिट्रेशन एग्रीमेंट कहलाता है, वो क्लॉज में हो या अलग से कॉन्ट्रैक्ट हो, और जहाँ सपोजिशन हो, इफ्स एंड बट्स हो, वो आर्बिट्रेशन एग्रीमेंट नहीं है. सिंपल सी बात है. अब इतना एक्सप्लेन किया उन्होंने, मैंने पढ़ के बताया, लेकिन इफ्स एंड बट्स से करनी है, साफ होना चाहिए. कोई भी कॉन्ट्रैक्ट डिस्प्यूट है, कॉन्ट्रैक्ट डिस्प्यूट क्रिमिनल डिस्प्यूट नहीं है, कोई भी कॉन्ट्रैक्ट डिस्प्यूट है, हम किसी को अपॉइंट करेंगे और उनको रेफ़र करेंगे, उसको हम दोनों मानेंगे, उसे कहते हैं आर्बिट्रेशन एग्रीमेंट. क्लियर कट, साफ साफ. और जनरली कंस्ट्रक्शन कॉन्ट्रैक्ट्स में ऐसा होता है, ईपीसी कॉन्ट्रैक्ट्स में ऐसा होता है कि कोर्ट में जाने की आवश्यकता नहीं है, आप अपना कोर्ट खुद ही बनाएं, दोनों मिलके. कोर्ट कह सकते हैं उसको आप उस पक्ष के लिए, या ट्रिब्यूनल कह सकते हैं. ट्रिब्यूनल भी एक तरह का कोर्ट होता है. Power to refer disputes, power to refer parties to arbitration where there is an arbitration agreement. There exists an arbitration agreement. A judicial authority before which an action is brought in a matter which is subject of an arbitration agreement shall, if party so applies, not later than when submitting his first statement on substance of dispute refers parties to arbitration. ये क्षमता है कि शक्ति है कि आर्बिट्रेशन को रेफर कैसे किया जाए. एक जुडिशियल अथॉरिटी, जज, before which an action is brought in a matter which is subject of an arbitration agreement shall, if a party so applies, not later than when submitting his first statement on substance of dispute refers parties to arbitration. Application referred to in subsection 1, as I said, shall not be entertained unless it is accompanied by original arbitration agreement or a duly certified copy thereof. Notwithstanding that an application has been made under that and issue is pending before judicial authority, an arbitration may be commenced or continued and an arbitral award made. उसके लिए आवश्यकता नहीं कि आप फैसले की वेट करें. अगर आपका आर्बिट्रेशन एग्रीमेंट है तो आप आर्बिट्रेशन स्टार्ट कर सकते हैं. नाउ कमेंट्स क्या हैं? अपॉइंटमेंट ऑफ आर्बिट्रेटर्स. It's not duty of court to adjourn a matter, to enable parties to report to court about appointment of arbitrators and then make reference. First statement on substance of dispute. Expression first statement on substance of dispute contained in subsection of section must be contradistinguished with expression written statement. It implies submission of party to jurisdiction of judicial authority. What is therefore needed is a fair finding of part of judicial authority that party has waived his right to invoke arbitration clause. If an application is filed before actually filing first statement on substance of dispute, party cannot be said to have waived right or acquiesced himself. Now, jurisdiction of civil court. Language of section 8 is preemptory in nature. Peremptory. Therefore, in cases where there is an arbitration clause in agreement, it is obligatory on court. It is obligatory on part of court or for court to refer parties to arbitration in terms of their arbitration agreement, and nothing remains to be decided in original action after such an application is made except to refer dispute to an arbitration. फिर आ गया jurisdiction of civil court. Language of section 8, as we said, is preemptory in nature. Therefore, in cases where there is an arbitration clause in agreement, it's obligatory for court to refer parties to arbitration in terms of their arbitration agreement, and nothing remains to be decided in original action after such an application is made except to refer dispute to arbitration. Mere existence of arbitration clause in agreement doesn't bar jurisdiction of the civil court automatically. Power of court to appoint arbitrator. Power of court to refer parties for arbitration would and must necessarily include, imply, and inhere in it. Well, scope and object. Now let us say scope and object. It's clause 8. Scope and object of section 8 of Arbitration and Conciliation Act 1996 and section 34 of Arbitration Act 1940 is different. Therefore, two respective provisions of different acts have no application to deprive party of legitimate rights to invoke section 8 of Arbitration and Conciliation Act. To have matter relating disputes refer to arbitration in terms of arbitration. Now, anti-measure. Now we'll go back to that one. We'll see. This is we're going to definition, arbitration agreement, arbitration award, arbitration tribunal. We have gone to this international commercial arbitration. So we because we shifted, and so arbitration award. Let's go through this again. Arbitration award since arbitration we defined and arbitration agreement we defined in section 7. Now arbitral award includes an interim award. We have to see that. Arbitral award includes an interim award. Arbitral award tribunal means a sole arbitrator or a panel of arbitrators. We have to understand these definitions because I shifted from this section 7 onwards for knowing arbitration agreement. Now arbitral award. So what is arbitral award? Includes an interim award, and arbitral tribunal means a sole arbitrator or a panel of arbitrators. Sole arbitrator is single person is there, single arbitrator is there, and a panel means 3 are there. Court means principal civil court of original jurisdiction in a district, or it includes high court in exercise of its original civil jurisdiction, having jurisdiction to decide questions forming subject matter of arbitration if same had been in subject matter of suit, but does not include civil court of a grade inferior to such principal civil court or any court of small causes. International commercial arbitration means an arbitration relating to disputes arising out of legal relationships, whether contractual or not, considered as commercial under law in force in our country India, and where at least one of parties is an individual who is a national law or habitually resident in any other country other than ours, a body corporate which is incorporated in other country other than in any country other than ours, India, a company or an association of body or individuals whose central management and control is exercised in other country, government of a foreign country, and legal representative means person who in law represents state of a deceased person and includes whatever person who intermeddles with estate of a deceased and where a party acts in a representative character. Person whom state devolves on death of a party also acting. Party means a party to an agreement. Arbitration agreement is what scope this part shall apply where place of arbitration is India. This part shall not affect other law for staying being enforced by virtue of which certain disputes may not be submitted to arbitration. Now this part, subsection 1 of section 40, section 41, 43 shall apply to every arbitration under whatever other enactment for time being in force, as if arbitration were pursuant to an arbitration agreement and as if that other enactment were in arbitration agreement, except insofar as provisions of this part are consistent with that other enactment or with what the rules made thereafter. So we will go through this section 40, 41 and 43 and subject to provisions of subsection 4, and that's what we talked of now, and save in so far as otherwise provided by law for time being in force or in agreement on force between ours and other country or countries. This part shall apply to all arbitrations and to all proceedings relating to construction of references. Where this part accepts section 28, this part accepts 28 leaves parties free to determine certain issue. The freedom shall include right of parties to authorize other person, including an institution, to determine that issue. So it's better PS2. Now you go for this section 40, 41, 43, and 28. Let's see what are those. Let's 28 first of all. Just so we little understand what 28 is. It's sometimes very difficult to coordinate this. And 28, let us say, what is 28? This is 28. Rule applicable to certain substances of disputes where place of arbitration is situated in India, in Bharat. This rule is applicable to substance of dispute where place of arbitration is situated in India. In an arbitration other than international commercial arbitration, arbitral tribunal shall decide dispute submitted to arbitration in accordance with substantial law for time being in this country, Bharat, India. In international commercial arbitration, arbitral tribunal shall decide dispute in accordance with rules of law designated by parties as applicable to substance of dispute, and designation by parties of law or legal system of a given country shall be construed, unless otherwise expressed, as directly referring to substantial law of that country and not to its conflict of law rules. Failing any designation of law under clause by parties, arbitral tribunal shall apply rule of law it considers to be appropriate given all circumstances surrounding dispute. Arbitral tribunal shall decide ex equo bono or as amicable composition only if parties have expressly authorized to do so. In cases, arbitral tribunal shall decide in accordance with terms of contract and shall take into account uses of trade applicable to Transactional Code 40, what 40 says, 40, 41, etc. 34 also I think there, 34 what 34 says, let me see. 34, application of settling aside arbitral laws is different. How to settle law, that we'll see later on. And you see 40. Arbitration agreement not to be discharged by death of a party. That's 40. Arbitration agreement not to be discharged by death of a party means अगर आपको death हो जाती है, आप ख़त्म नहीं कर देते, agreement ख़त्म नहीं हो जाता है. Arbitration agreement not to be decided by death of a party thereto. An arbitration agreement shall not be discharged by death of a party thereto either as respects the deceased or respects other party, but shall in such event be enforceable by or against legal representative of deceased. Mandate of an arbitration shall not be terminated by death of any person by whom it was appointed. Nothing in this section shall affect operation of any law by virtue of which any right of action is extinguished by death of a person. And 41 provisions in case of insolvency, we'll go through that. दिवालियापन, उसके बाद क्या होता है, provisions in case of insolvency, and also jurisdiction, notwithstanding anything contained elsewhere in this part of any other law of time being in force, where with respect to arbitration agreement, application under this part has been made in court, that court alone shall have jurisdiction over arbitral proceedings and all subsequent applications arising out of that agreement and arbitral proceedings shall be made in court and no other court. And also jurisdiction of court and limitations, arbitral and conciliation act limitations. Limitation act is limitation means filing time. Limitation act shall apply to arbitrations as it applies to proceedings in court. Limitation act 1963 shall apply to arbitrations as it applies to proceedings in court, and for purpose of this section, a limitation act and arbitration shall be deemed to have commenced on date effective in section 21. Section 21 will see, okay, where an arbitration agreement to submit future disputes, arbitration provides that whatever claims to which the agreement applies shall be barred unless some step to commence arbitral proceeding is taken within a time fixed by agreement and a dispute arises to which Agreement applies, quote, if it's opinion that in circumstances of case undue hardship would otherwise be caused, and notwithstanding that times of fixed has expired, it may, on such terms, if whatever is justice of case may require extend time for such period as it thinks proper. Where court orders that where court orders that arbitral award be set aside, period between commencement of arbitration and date of order of court shall be excluded in computing time prescribed by Limitation Act. So we go to page 2, now back. 41, 43 we've gone through, so we can now go. It says this part in section 40, 41, 43 shall apply to every arbitration under other enactment for time being in force, as if arbitration were pursuant to any arbitration enactment, and if so, or if that enactment wherein arbitration agreement except so far as provisions of this part are inconsistent with that other enactment. So we'll go further. Subject to provisions of subclause this and so far as otherwise provided in law for time being in force, an agreement in force between India and another countries partially apply to. We have gone through this one. So what is that? Let us see. Say, we gone through this. Subject to provisions of subclause and so far as otherwise provided by law for time in force or an agreement in force between India and other countries, this part shall apply to all arbitrations and to all proceedings relating to construction of references. With this part, except section 28, leaves parties to determine certain issues that freedom shall include right of parties to authorize any person, including an institution, to determine that issue, and this is that section 21. An arbitral award made under this part shall be considered as domestic award. 20, where this part, refers to fact that parties have agreed to, or that they may agree, or in whatever other ways refers to agreement of parties. That agreement shall include arbitration rules referred to in that agreement. Where this part, other than clause section 25, clause of section 32 refers to claim, it shall also apply to counterclaim, and where it refers to defense, it shall also apply to defense to that. So comments. Now it's the comments is international commercial arbitration. Is a comment only. International commercial arbitration is scope of where at least one of parties, an individual having nationality of another country other than this country, India, or a body corporate which is incorporated in another country, an association of body individuals whose central management and control is exercised in another country than in this country, Bharat, India, or government of foreign country. Same would be a case of international commercial arbitration. Respondent here is in body corporate which is incorporated in country other than this country, Bharat, and therefore in terms of aforesaid definition of present admittedly is case of international commercial arbitration. So this definition, how to know. Arbitration consists in the receipt of written communication unless otherwise agreed by parties. Written communication, whatever it is, written communication is deemed to have been received if it is delivered to addressee personally or at its place of business. Its place of business, habitual residence, or mailing address. If none of places referred to in this case can be found after making a reasonable inquiry, a written communication is deemed to have been received if it is signed to addressee, last known place of business. Habitual residence or mailing address, habitual residence or mailing address by a registered letter or by whatever other means which provides a record of attempt to deliver it. Communication is deemed to have been received on day it is so delivered. This section doesn't apply to written communications in respect of proceedings of whatever judicial authority. Arbitration and Conciliation Act. Waiver of rights to object. Waiver of right to object. What does it say? A party who knows that whatever provision of this part from which parties may derogate or requirement under arbitration agreement has not been complied with and yet proceeds with arbitration without stating its objection to such non-compliance without undue delay, or if a time limit is provided for stating that objection within that period of time shall be deemed to have waived its right or so objects. अगर इसमें कुछ था, ऑब्जेक्शन करने का टाइम था, आपने ऑब्जेक्शन नहीं किया, उस प्रोविजन को यूज़ नहीं किया, तो वो वेव हो गया ऑटोमेटिकली. A party who knows that provision of this part from which parties may derogate or requirement under arbitration agreement has not been complied with and yet proceeds with arbitration without stating its objection to such non-compliance without undue delay, or if a time limit is provided for stating that objection within that period of time, shall be deemed to have waived its right to so object. Arbitration and Conciliation Act, extent of judicial intervention. Notwithstanding anything contained in other law for time being in force in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Alright, so let's go further. Administrative assistance. In order to facilitate conduct of arbitral proceedings, parties or arbitral tribunal, with consent of parties, may arrange for administrative assistance by a suitable institution or person. Arbitration agreement. In this part, arbitration agreement means an agreement by parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined gone through this already, so now we go on to power to refer parties to arbitration where there is no arbitration agreement. Already we have gone through this, so no problem, I repeat, this is important. A judicial authority before which an action is brought in a matter which is subject of an arbitration agreement shall, if a party so applies not later than when submitting his first statements on substance of dispute, refer parties to arbitration. Application referred to in this shall not be entertained unless it is accompanied by original arbitration agreement or duly certified copy. So that's what it says. Then we don't go to comments, we go to further as not to waste time. So it says interim measures accepted by court. A party may, before or during arbitral proceedings or whatever time after making of an arbitral award, but before it is enforced in accordance with section 36 applied to court. Section 36, we'll see what is that. For appointment of a guardian for minor or a person of unsound mind for purposes of arbitral proceedings. For an interim measure of protection in respect of any of following matters: preservation, interim custody or sale of any goods which are subject matter of arbitration agreement, securing amount in dispute in arbitration, detention, preservation or inspection of property or whatever else which is of subject matter of dispute in arbitration or as to which any or whatever question may arise therein, authorizing for an aforesaid purpose person to enter upon whatever land, building or position of whatever party, authorizing whatever samples to be taken or whatever observation to be made or experiment to be tried, which may be necessary or expedient for purpose of obtaining full information or evidence, interim injunction or appointment of receiver, such other interim measure of protection as may appear in court to be just and convenient. Court shall have same power for making orders as it has for purpose of and in relation to any other proceedings before it. Interim protection. A party or a person is entitled to interim protection if action of other party is either in breach of terms of agreement, etc., is given. Pending of whatever arbitration proceeding is not a precondition for exercise of power by court. Pendency of arbitration proceeding is not a precondition for exercise of power by court. Court may grant interim relief before during arbitral proceedings or another time making of arbitral award. Scope. Section 9 of Arbitration and Conciliation Act only deals with interim measures by court. Obviously, it's not within the scope of this section to inquire into claim. Alright. Number of arbitrators, let us see. It's according to this clause 10, number of arbitrators. Parties are free to determine number of arbitrators provided that such number shall not be even. 2, 4, 6 not allowed, 3, 5, 7, 9 can be allowed. Parties are free to determine number of arbitrators, provided such number shall not be an even number. 2, 4, 6, 8 नहीं चलेगा, 1, 3, 5, 7, 9 चलेगा. Failing determination refer to subject arbitral tribunal shall consist of sole arbitrator. अगर आपने नंबर नहीं लिखे तो सिंगल तो आएगा ही आएगा. Number of arbitrators comments देखिए. Parties are at liberty to determine numbers of arbitrators, but such number shall not be an even number. If parties fail to provide for an odd number of arbitrators, the arbitral tribunal shall be constituted by sole arbitrator. So we leave this case. Appointment of arbitrators. Appointment of arbitrators, and I'll also go to at this moment to, I think it is some Arbitration Amendments Act. This is 218, and where is the act? I think it was 215, 18. I to open 15 and 18. I think it will be better if we do that. Let me go to directly first of all. Let's see what this says. Article Section 11. This act. What does it say? A person of whatever nationality, may be arbitrator, may be an arbitrator. किसी भी राष्ट्रीय तो क्या कहते हैं नेशनलिटी को, किसी भी नेशनलिटी का आदमी, किसी भी राष्ट्र का आदमी आर्बिट्रेटर हो सकता है जब तक कि पार्टियां ना फैसला ना करें. Parties are free to agree on a procedure for appointing arbitrators. पार्टियों को स्वतंत्रता है कि वो आर्बिट्रेटर को कैसे अपॉइंट करें. Failing agreement refer to in an arbitration with 3 arbitrators, each party shall appoint 1 arbitrator. अगर आपने 3 आर्बिट्रेटर का फैसला किया है तो एक एक दोनों अपॉइंट करें. In an arbitration with 3 arbitrators, each party shall appoint 1 arbitrator, and 2 appointed arbitrators shall appoint 3rd arbitrator, who shall act as presiding arbitrator. जो कि चेयरमैन होगा, प्रेसिडेंट होगा और स्टेट दल का. तीसरा वन जो दोनों मिलके करेंगे. If appointment procedure applies and a party fails to appoint an arbitrator within 30 days from receipt of request to do so from other party, or 2 appointed arbitrators fail to agree on 3rd arbitrator within 30 days from date of their appointment, appointment shall be made upon request of a party by Chief Justice or other person or institution designated by him. This is when you fail to appoint party, then Chief Justice or other person or institution designated by that justice. Failing agreement referred to in an arbitration with the sole arbitrator. If parties fail to agree on arbitrator within 30 days from receipt of request by one party from other party to do so, to agree points shall be made upon request by party by Chief Justice or person or institution designated by him. Whereunder an appointment procedure agreed upon by parties, a party fails to act as required under that procedure, or parties or 2 appointed arbitrators fail to reach an agreement expected of them under that procedure. A person, including an institution, fails to perform any function entrusted to it under that procedure, a party may request Chief Justice to or any other person or institution designated by him to take necessary measures unless the agreement of appointment procedure provides other means for securing appointment. A decision on matter entrusted by subsection 4 and 5 of subsection 6 to Chief Justice or person or institution designated by him. Chief Justice or person or institution designated by it in appointing an arbitrator shall have due regard to whatever qualifications required of arbitration by agreement of parties, other considerations likely to secure appointment of an independent and impartial arbitrator. In case appointment of sole or third arbitrators in international commercial arbitration, Chief Justice of India. In case of appointment of a sole or third arbitrator in an international commercial arbitration, Chief Justice of India or person or institution designated by him. may appoint an arbitrator of a nationality other than nationalities of parties where parties belong to different nationalities. Chief Justice may make such scheme as may deem appropriate for dealing with matters entrusted. Where more than one request has been made under these sections, Chief Justice of different high courts or their designates, Chief Justice or designate to whom request has been first made, under relevant subsections shall alone be competent to decide on request. Where matters referred to in these sections 4, 5, 6, 7, 8 and 10 arise and international commercial arbitration reference to Chief Justice in those subsections shall be constituted as reference to Chief Justice of India. Where matters referred to subsections these 4, 5, 6, 7, 8, 10 arise in any other arbitration, reference Chief Justice in those subsections shall be constituted as reference Chief Justice of High Court within those local limits principal civil court referred to is situate, and where High Court itself is court referred to in that clause to Chief Justice High Court. So leave it. So we go further. We go to ground for challenge. We'll go to ground for challenge, and let's first go to our these amendments. We start with this so that we can well understand legal records, and this is my folder here, and this action law. So I'll go to start here. Arbitration Act, let's open Arbitration Constitution Act 15, then 18, then 19. Let's say first of all 15. Arbitration Constitution Act 15 I'm opening, and we'll see that in 2015 it is there. It's Gazette of India Bharat Rajpatra, New Delhi, Friday, January 1st, 2016. And Ministry of Law and Justice, Legislative Department, 1st January 2016. This is amendment 2015. Following Act of Parliament received assent to President, etc., in December 2015, and this amendment number 3 of an Act to amend Arbitration Act, Constitution Act 1996. Okay, and that's it here. Says this act may be called Arbitration and Conciliation Amendment Act 2015. It shall be deemed to have come into force on 23rd October 2015, and this is what here says. Now says in section 2, what is section 2? Let's see what is section 2 here. I think I should close this file better. I will see this later on. I'm closing this file. So it's here, you can say we go to this one. We go to class number section 2. Let's see section 2. Let's go for section 2 first of all. Definitions. What is that? Here it says definition, and what this says. Section 2 in subsection I. Subsection I, and that subsection is here. Maybe GHI, no, GH. Listen, maybe I'm wrong. 1 A B C D E F G E F. It says something. I in subsection 1. I A for clause E. Clause E. Following clause shall be substituted. Okay. Let us see. This is some confusion. Court. It's court. Okay. This is as court says. What is court means? In this it says, in case of an arbitration other than international commercial arbitration, principal court of original jurisdiction in a district, it includes High Court in exercise of its original jurisdiction, original civil jurisdiction, having jurisdiction to decide questions forming subject matter of arbitration, if same had been subject matter of a suit, but does not include civil court of grade inferior to such principal civil court or any court of small cause. In case of international commercial arbitration, High Court in exercise of its ordinary horizontal jurisdiction, having jurisdiction to decide questions forming subject matter of arbitration if same had been subject matter of suit, and other cases a high court having jurisdiction to hear appeals from decrees of court subordinate high court. In case of international commercial arbitration, high court in exercise of its ordinary jurisdiction, ordinary original civil jurisdiction having jurisdiction to decide questions forming subject matter of arbitration if same had been subject matter of a suit. Other cases, high court having jurisdiction to hear appeals from decrees. So what's the difference here? You see that? If you read that one, it says in this clause, original one, which has been applied, court means principal civil court of original jurisdiction in a district, and includes the high court in exercise of its original civil jurisdiction, having jurisdiction to decide questions forming subject matter of arbitration of same had been subject matter of suit, but does not include any civil court or grade inferior to such principal court. So this is E here, if you see that one. And it's a little different. In case of arbitration other than international commercial arbitration, in case of an arbitration other than international commercial arbitration, principal civil court of original jurisdiction in a district, and includes the high court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide questions forming subject matter of arbitration if same had been subject matter of a suit, but does not include any civil court of a grade inferior to such principal civil court or any court of small cause. So what's the differences? Means principal civil court of original jurisdiction in district, and includes high court in exercise of original civil jurisdiction, having jurisdiction to decide questions forming subject matter of the same had been subject matter of civil suit, but does not include any civil court of grade inferior to such principal civil court. Okay. Now it's in F. F you say in case of international commercial, it's added here. It says as international commercial arbitration means an arbitration relating to dispute arising out of legal relations where contracts are not considered as commercial under law enforced in India and where adjacent party is an initial. So what in this case it says, in case of international commercial arbitration, High Court in exercise of its original civil jurisdiction, having jurisdiction to decide questions forming subject matter of arbitration if same had been subject matter of a suit, and in